Good evening, everyone. We'll start with Unit 2, Laws Related to Contract in Business Law. In laws related to contract, there are six headings which we have to study: Indian Contract Act 1872, contract, contingent contract, performance of contract, discharge of contract, and breach of contract. So, these are the six things we'll study. Indian Contract Act 1872. Indian Contract Act 1872 prescribes the law relating to contracts in India. The Act is based on the principle of English common law. It is applicable to all the states of India except the state of Jammu and Kashmir. Now it is applicable to Jammu and Kashmir also. Under Section 2H, the Indian Contract Act defines a contract as an agreement which is enforceable by law. So, what is contract? It is an agreement which is enforceable by law. If you want to look into mathematical format, then offer plus acceptance is agreement, and offer plus acceptance plus legal enforceability is a contract. So, agreement plus legal enforceability is a contract. Offer, Section 2A. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So, whenever one person signifies to another his willingness to do or abstain from doing something, so doing to do something or to abstain from doing something with a view to obtaining the assent of the other. To what is the purpose? To view to obtain the assent of the other. Such for such act or such abstinence, it is called to make a proposal. Acceptance: when the person to whom proposal is made signifies his assent thereto, the proposal is said to be accepted. So, the person to whom the proposal is made, when he signifies his assent, it is called as acceptance. Promise: a proposal when accepted becomes a promise. In simple words, when an offer is accepted, it becomes a promise. Promiser and promisee. Section 2C. When the proposal is accepted, the person making the proposal is called promiser and the person accepting the proposal is called as promisee. Consideration. Section 2D. When at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. Price paid by one party for the promise of the other. Technical word meaning quid pro quo, that is something in return, is consideration. Now, agreement. Every promise and set of promises forming consideration for each other is called agreement. Reciprocal promises. Promises which form the consideration or part of consideration for each other are called reciprocal promises. Void agreement. An agreement not enforceable by law is void. Voidable agreement. An agreement is a voidable contract if it is enforceable by law at the option of one or more of the parties thereto. So, one or more parties have the option whether to enforce it or not, then it is voidable contract, and it is not enforceable by law at the option of the other or others. Void contract. Contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Contract. Contract is an agreement enforceable by law. Now, types of contract on the basis of enforceability. Valid contract. Valid contract means a contract which has all the conditions fulfilled which has been mentioned in Section 10 of the Contract Act. Void contract, a contract which is not enforceable. Void agreement, an agreement which is not enforceable. Voidable contract, a contract which is voidable at the option of the one party. Illegal contract, the contract whose purpose is illegal. Unenforceable contract, the contract which cannot be enforced is which is impossible to be enforced is called an unenforceable contract. Now, on the basis of formation, express contract, the contract which has been made by oral or written in an oral or written manner. Implied contract, the contract which is evident from the act of the party. Quasi contract, a contract which is not a contract but it becomes a contract. For example, if a person gets something which is missed by some other party, then the contract comes up between these two parties. On the basis of performance, executed contract, the contract which has been executed by both the parties, executory contract, the contract which is to be executed, it has not been executed yet. On the basis of obligation, unilateral contract, the contract in which one party is obliged to do something for other. Bilateral contract, where both the parties are obliged to do something for the other. Essentials of a valid contract. Proper accept. So these are the 10 essentials of the contract. These have been mentioned in section 10 of the Indian Contract Act. These are proper offer and its acceptance. The objective of the contract should be lawful. Agreement not expressly declared void. So agreement should not be declared void. Intention to create legal relationships, so legal enforceability has to be there. Free consent is very important. The consent should not be driven by any misrepresentation, or it should not be through coercion. It should be free. Then the parties should be in the capacity to make a contract. There should be certainty of meaning of the contract. Then there should be possibility of performance. The consideration to the contract should be lawful, and all the legal formalities which are required in case, if any, for the contract to become valid should be executed, should be done. Now, what is contingent contract? A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Illustration: a contract to pay to B rupees 10,000 if B's house is burned. This is a contingent contract. Contingent contract because rupees 10,000 will be payable only if B's house is burned. What are the characteristics of a contingent contract? Existence of contingency, collaterality. So there will be some collateral event always on the happening of which the contract will become active. Uncertainty is always there, and enforceability is always there. Now, rules regarding contingent contract: enforcement of contract on happening of a future uncertain event, enforcement of contract on the non-happening of the future uncertain event. So that will not be, though that is valid, but that won't be enforced. Contract contingent on the future conduct of a living person. So there can be future conduct of a living person, the which contract can be contingent. The contracts contingent on the specified event happening within a fixed time. So there, within a fixed time, there can be certain event on the happening of which the contract can become active. Enforcement of contingent contract on specified event not happening within a specified time. So if that event does not happen within a specified time, then also that contract can become valid. So these are the 5 rules regarding contingent contract. Now, performance of a contract. The term performance of a contract means that both the promisor and the promisee have fulfilled their respective obligations which the contract placed upon them. For instance, A visits a stationery shop to buy a calendar. The shopkeeper delivers the calculator. A visits a stationery shop to buy a calculator. The shopkeeper delivers the calculator and A pays the price. The contract is said to have been discharged by the mutual performance. Now, types of performance of a contract. There are 2 types: actual performance and offer to perform or tender or attempted performance. So actual performance is when you actually perform the contract. Offer to perform or tender or attempted performance is when one party is offering to perform or attempt the performance has been attempted, but that has not really happened. Who may perform? Performer, promisor himself may perform, his agent may perform, representative may perform, any third person who is authorized by the promisor may perform, joint promisors, if any, then any one of those promisor can perform. Who may demand performance? Promisee can demand performance, his agent can demand performance, legal representative can demand, any third person who is authorized by the promisee can demand performance. Now, discharge of contract. As per Indian Contract Act, discharge of contract means the termination of a contractual relationship between the parties. A contract is said to be discharged when it ceases to operate, that is, when the rights and obligation created by it come to an end. What are the modes of discharge? By actual performance. Actual performance, how many types of performance are there? Actual and attempted. By impossibility of performance, in case if the performance of the contract becomes impossible, then also the contract is said to be discharged. By the lapse of time, maybe the time frame for which the contract was there, that has been lapsed. so the contract becomes discharged. By the breach of a contract, there can be breach, so there can be actual breach or anticipatory breach. Actual breach means when the party who was obliged to perform but he didn't perform. Anticipatory means party who was to perform who was to perform, but it is anticipated that he won't perform. Now, by mutual agreement, there can be novation. Novation means the contract can be renewed, some new contract can be, some new clauses can be added. Rescission, the contract has been taken back. Alteration, there are changes in the sections of the contract. Remission, there can be change in the or extension of the contract. Waiver, the contract, there are certain parameters which have been waived. Merger, so there can be the contract can be merged with some other contract. By operation of law, so maybe death of the party, merger, so again the contract has been merged. Insolvency of the parties and unauthorized alteration, there is some alteration in the contract which has been made which was not authorized as per the terms of the contract. So these are the modes of discharge of the contract. So there are 6 modes of discharge of contract: by performance, by mutual agreement, by impossibility of performance, by operation of law, by lapse of time, or by the breach of the contract. And there are subtypes. Now, remedies for breach of contract. As per the Indian Contract Act 1872, discharge of contract means the termination of the contractual relationship between the parties. A contract is said to be discharged when it ceases to be in operation. That is when the rights and obligation created by it come to an end. What are the remedies? In case if someone breaches the contract, what are the remedies? Common law, you can claim damages, and equitable remedies, then there are rescission. You can ask that okay, because you are going through this, you're taking back the contract. Restitution, you can reinforce the contract. Specific performance, you can go to the court and say, like, I want this contract to be executed specifically the way it was meant to be, and the court can order that. Injunction, you can stop the performance or non-performance. Quantum merit, you can ask the quantum merit and Anton pillar order. This we will discuss in the future slides. So these are the 2 things which we will discuss in the future slides. So remedies for the breach, there can be damages and there can be equitable remedies. Equitable remedies are rescission of the contract, means contract taken back. Restitution of the contract, again coming back of the contract. Specific performance of the contract. Injunction is stopping the further performance of the contract. Quantum merit and Anton pillar order. Anton pillar order and quantum merit we'll discuss in the future slides, so in the coming slides. So thanks for the time being. I hope this second unit was easier one. Please go through this and give me a feedback. Thank you.